Yes, it's working. All right, we're back on the record, the State versus Holloway, about to continue to the second phase of the trial on the issue of felon in possession of a firearm. My plan is to review the indictment with them and tell them per this instruction that we're just addressing the third element of that indictment because they've addressed the first two. And then after I give them this instruction, we also have a verdict form for them that they would answer as part of their deliberation. Attorney Hunt.
Thank you, Your Honor. Thanks for making that clear. With respect to the first-degree assaults and the second-degree assault, there was some discussion we had previously, I think maybe late last week.
That's true. Yeah,
I just
haven't
wanted to
reviewed that.
we just wanted to make sure that there's an order saying that we did not have to prove the sentence enhancement language in this case. That's only language necessary for sentencing.
Yes, I have reviewed the Apprendi case, reviewed the specific statute. That section of the statute regarding these extended term notices indicate that the decision is solely for the court, and since they are convictions, that complies with the Apprendi case, so the jury does not have to make any determinations on the first-degree or second-degree assault charges. The notice of extended term is only for my consideration at time of sentencing, and I'll have the discretion to either impose it or not. But it does not have to be proven beyond a reasonable doubt in front of the jury. I did take a look at that and tell you that, so I'm glad you raised that.
And Your Honor, just one more quick thing. I know the state's talked with Attorney Duckett. We've made the appropriate calls to our witnesses. I know when we broke.
Sure.
And so I think we're still in the process of trying to get in touch with Ms. Potter. Keith Myers will be here tomorrow morning. Attorney Duckett, I don't know if you want to go over the scheduling now.
Go right ahead, Attorney Duckett.
Sure. It's my understanding that Patricia Garcia will be recalled by Dale. His
Are you
mom.
recalling Ms. Garcia?
Yeah, Sean.
That's fine, thank
So
you.
that will be tomorrow at 9:30. I've spoken with Investigator Will Freiler. He is available tomorrow at 9:30.
Good.
It's my understanding that the state, in addition to Ms. Potter, will have Jason Meyer available tomorrow.
Great.
There's also some jail calls that will be introduced by Pete Terrio. I think Mr. Terrio is available tomorrow.
Very good.
Ms. Tabashnik is here, available for this afternoon.
Good.
And from what I understand, Dr. Mark is only available Thursday, but I asked him to be here at 9 o'clock.
All right.
And we can have Dr. Bader, Your Honor, be here right Thursday morning so that there's no lag time.
Okay. Yeah, my concern is I don't want any lag time at all because of the schedule, so I'm concerned that if for some reason we get through these witnesses tomorrow quickly and we're done by, say, 1 or 2 o'clock, I'd hate to see them go home without any further testimony. Obviously, I don't know if Mr. Holloway is going to testify or not. He doesn't have to disclose that yet. So I think we just work it as it is now and go forward. I think you just leave that Dr. Mark on for 9 o'clock.
And do you want me to find out if he also has availability for Wednesday afternoon
I would
in that
prefer-
event?
Yeah, and tell him 2 o'clock.
Okay.
That would be better.
All right.
Okay, we'll see how it goes.
Understood.
Obviously, we have to complete this phase too, so but if we can get Dr. Pajanic in today, that would be fantastic.
Thank you, Your Honor.
We'll see what happens. All right, just so Mr. Holloway, you know, and the state knows, my plan is to review the indictment with them again, tell them that their sole determination now is there's a third element to this indictment that they've heard me read, and they have to determine that using the legal instructions they already have, but only the legal instruction as it relates to the charged offenses for this particular indictment, the possession of a firearm indictment. So I have a brief instruction for them beforehand, and then I have a verdict question form for them just on that final element. Their findings on the first 2 elements have been met by the guilty finding that was just rendered. All right. Any other preliminary issues, State?
No, Your Honor.
Mr. Holloway, we ready to go?
Yeah, I'm ready now.
Okay, thank you. All right, let's have the jurors come in.
All rise for the jury.
Please be seated, everybody. First of all, thank you for your patience, and believe me, I understand that you may well have been thinking not too long ago that we have completed our deliberations and we are done with our service for reasons that are really related to the evidence in this case. There are other determinations that you have to make in the next two phases of the case. The first phase is completed, and now we are on to the second phase, so let me explain this phase to you. As you know, you reached a guilty verdict on charge ID number 1678544C. That's the possession of a firearm. There is an additional element that you have to reach a finding on for a verdict on this particular charge. There were evidentiary reasons why we did not advise you of that final element. You will be advised of it now, and your sole focus will be on a question I will ask you about the final and third element of this indictment. Let me read the indictment to you in full because it was not read to you in full at the time we started the case, and it was not listed in full in the jury instructions I gave you. Obviously, that was intentional, but you're going to hear the whole indictment now. This indictment charges that on or about the 12th day of October 2019 at Pelham in the county of...
Excuse me, sorry.
Oh, God bless.
Thank you.
At Pelham in the county of Hillsborough, aforesaid, did commit the crime of pistols and revolvers, convicted felony, that's a felon in possession of a firearm, in that he knowingly had in his possession a firearm, specifically a .380 caliber pistol, after having previously been convicted in the Commonwealth of Massachusetts of a felony against the person or property of another, specifically assault and battery with a dangerous weapon and assault to kill in the Suffolk County Superior Court in 2003 under docket number 01104670001 and 01104670002. As I've told you, there is a third element of this crime. The third element of this crime requires the state to prove beyond a reasonable doubt that the defendant has been convicted in either a state or a federal court in this or any other state of a felony against the person or property of another. That's the final element. You've already reached a finding of guilty on the first two elements. As such, your sole determination for this phase of the trial is whether or not the state has proved this part or element beyond a reasonable doubt. Importantly, as you make this decision, please use the legal instructions provided to you during the first phase of the trial related to the following topics: function of the court, indictment not evidence, possible punishment not relevant, defendant did not testify, that may or may not occur. I don't know if Mr. Holloway will exercise his right to testify, so that may be in play. Jury recollection controls, evidence in the case, direct and circumstantial evidence, credibility of witnesses, prior inconsistent statements, expert testimony I don't think will apply in this phase, but we'll see. Number of witnesses, that's quantity and quality of the evidence, burden of proof. The criminal offense that you will be looking at in this case is solely charge ID number 1678544C, the possession of firearm charge, but just that third element. You do not have to look at all of the other charged offenses at all. Multiple charges and duty to deliberate. So it's really more of the general instructions. The only charge you're focused on is what we've labeled the possession of a firearm charge. And within that charge, the only element you are concerned with is whether the state proves beyond a reasonable doubt that Mr. Holloway has been convicted in either a state or federal court in this or any other state of a felony against the person or property of another. I'll give you this instruction in writing, and then there will be a verdict form, should call it a verdict of question, on possession of a firearm, which will ask you the question, do you find the state has proved that the defendant has been convicted in either a state or federal court in this or any other state of a felony against the person or property of another? There'll be a yes box and a no box. All right? Is that clear to everybody? Thank you. All right, we'll proceed with the second phase of the trial. Again, the state has the burden of proof beyond a reasonable doubt, so the state will go first. Do you want to do an opening statement?
Yes, Your Honor.
You may proceed.
Thank you. I'll be quick. For this phase of this trial, we're going to introduce one document, the conviction. It's a certified copy of the conviction. We'll have this. This will be the proof showing Mr. Holloway's prior conviction. This will meet the burden that Judge Temple just described. And after that, I may give a closing argument on these facts. Thank you.
Thank you. Mr. Holloway, do you have any openings?
Yes, Sean,
Go right ahead, sir.
and I'll be quick as well. We're all citizens. I was born in America. My mother gave birth to me in Boston. I moved from Boston. And I live in New Hampshire now. I have a New Hampshire ID. You heard testimony about me having my ID on me the day of question. The state's going to show you a conviction from 2003, May 14, 2003. That's 20 years ago, over 20 years ago. So, you should know that my civil rights have been restored since that time. I paid taxes, I voted, things like that, the normal. So I assume I'm normal now, unless I'm still a slave to Massachusetts. Thank you.
Thank you, Mr. Holloway. And your first witness or exhibit?
All right, I'd ask the bailiff once again to go up to the exhibit table and get State's Exhibit 31. And at this point, I'd ask the bailiff to approach, well, actually to show to Mr. Holloway, after which I'd ask the bailiff to approach Your Honor with this document, because at this point, we're going to ask that the ID be stricken and that this be marked as a full exhibit.
Your Honor, I object.
And what is the basis of your objection?
State's exhibit has excessive amount of additional information that would be inflammatory to the jurors.
All right, let me take a look at that, and I'll consider that objection. And Attorney Harding, what I would ask, is there any need outside of the two indictments and the disposition of those indictments with the seal and attestation on them to provide any of the what's labeled financial information and informal docket marking?
Yes, Your Honor, and I would point the court to the entry for September 26, 2015. I think that may be page 5 or 6.
You said September 26th,
What my note has.
2018,
September 26, 2015.
2015.
I see page 10.
These are all on there. You're gonna have to give me a page number because I'm missing that date. Maybe it's just me.
Judge, I don't have
I have it.
the, okay.
Okay, well, you said September 26,
2015.
2015. Is that the only entry you need at this point? Out of these, all these entries?
So just to be clear, this is what we received from Massachusetts. a
Correct.
certified copy. We're anticipating introducing all of this. I don't know exactly what Mr. Holloway was referring to as inflammatory. So we would ask that the entire conviction be introduced. If Mr. Holloway could point to something that's inflammatory or irrelevant, I suppose we could have a discussion about that. But specifically, I am looking at that, what's written there for that date of September 26, 2015.
All right, let me just check one out with them. And Mr. Holloway, just so I'm clear with you, I need to know exactly what you're asking me to strike. I see the two indictments that I would not in any way consider striking. I see the disposition of the charges on the page, it's the third page of this entry. And then there's certain financial details and then a complete informational docket entry system that ranges multiple years, beginning in 2001 and ending as recently as October 5th, 2023. Is that what you're moving to strike from this exhibit?
Yes, Sean, I think the informational docket entries entirely would be prejudicial. Also, looking at the events section 2 to 4, And I think that that would be the same. If you look at the contents of it, it suggests things other than what the state is trying to prove. I think the first page is enough. It says what the state is trying to prove, and that's the disposition of those convictions. So I think page 1 should be eligible and the rest should be stricken from the record.
All right. Any other arguments from the state at all? Other than the September 26th entry
Right,
of 2015?
which regards the biographical detail.
Correct.
Correct. So,
Correct.
again, well, I'm not going to restate the argument, but the goal, the state's purpose here is to introduce the entire conviction so the jury has this. We haven't heard anything from Mr. Holloway that says that anything is inflammatory, or at least that's not what I've heard. So we would ask still for the entire conviction from Massachusetts be admitted.
All right. In my view, the informational docket entries, the information itself are docket entries. I don't know if inflammatory is the right word, but I don't think it's necessary for this jury to review all of that. It involves other entries outside of the actual 2 convictions you're seeking to prove, and I think it could mislead and confuse the jurors as to why they're looking at all of those entries. However, the entry that you're referring to on September 26th is more identity based. So I think that's an appropriate entry for them to review, specifically the entry that's on page 8 of that informational docket listing that lists the name of the party and the party's alias name. So what I will do is we'll redact all of this information so that the record will remain clear in terms of what you submitted, and the only docket entry will be the entry for September 26th of 2015. I mean, there are entries ranging from 2001 to 2023, as recently as October 5th, that do not provide a basis for proving the conviction. So I think the conviction certainly has to go in, and will redact the other information. So subject to that ruling, Exhibit 31 is admitted, and when I say admitted, the first indictment charging a crime on March 21, 2001 of being armed with a dangerous weapon, to with a knife, to assault Tyree Hearing with intent to murder him. That indictment is part of the certified conviction. The second indictment, same date, March 21, 2001, did commit an assault and battery upon one Tyree Hearing by means of a dangerous weapon, to wit a knife. That is admitted as part of the certificate of conviction. And then the third page, which is labeled Public Docket Report, with information regarding the actual conviction, is on page 3, and the jury can review that also. So the first 3 pages would be admitted as part of Exhibit 31. So those will be admitted. I will remove the other pages of the docket informational, the public docket report regarding financial details. I will remove pages like 3, it's hard to read, 4, 5, 6, 7, 9, 10, and 11 of that docket report, on the basis under Rule 403 that it will only lead to confusion and misleading the jury as to their task. I will admit page 8 of that docket report, specifically the entry for 9/26/2015, which lists the identity of the party and the alias of the party. So Liz, all of the other information on that page would be redacted, and that will go in front of the jury in a redacted fashion. So that goes over to Liz.
Thank you, Your Honor.
You're welcome. That goes over to Liz also, but I'll paper clip it, and that will not go in as an exhibit for the jury's consideration. We should mark it as ID so that it can be reviewed if necessary. And you can ID it whatever number you're at. Okay, so just to be clear, Exhibit 31 is admitted as a full exhibit, subject to the court's ruling and the redaction on that one page.
Oh, so the stuff you're excluding is going to be 40.
Okay, Exhibit 40 will be the ID on the docket entry sheet. And just so all of you are clear, all that mumbo jumbo means you're getting the 3 pages as Exhibit 31. That's what you should review in your deliberations. You won't see anything about the docket entries that I've talked about. I've basically ruled that those are not for your consideration. One of the pages you will see will be totally blacked out except for one entry. And you can review those and determine what those mean in this particular case. So when I'm saying indictments and dispositions and/or convictions, that's not me determining anything. That's me describing the document. You're to look at it carefully and determine what that document means as evidence in this case, just to be clear. All right? Thank you.
Thank you, Your Honor. With that, the state rests.
All right, the state has rested. And Mr. Holloway, the state has rested. Do you have any witnesses that you're going to call?
I wasn't prepared to call a witness on this case.
Okay,
I didn't,
no, that's fine.
I didn't understand that that would be an option.
No, it is, but if you don't have any witnesses,
Well,
that's
not call
fine.
myself as a witness.
You may call yourself as a witness, obviously limited to this specific element. So if you would like to do that, I can place you under oath, and you can say what you have to say, and you'll be subject to cross-examination. So if you'd stand, please. If you raise your right hand, do you swear that the testimony you're about to give will be the truth and nothing but the truth under the pains and penalties of perjury?
I do.
Before you testify, though, if I could just excuse you for a minute. I know I'm wearing on your patience, I'm sure, but I just want to discuss something before we go forward.
All rise for the jury.
All right, thank you. You may be seated, Mr. Holloway. Also, I just want to make sure that you understand in terms of your testimony being limited to this particular indictment. Doesn't any way limit your testimony as to the next phase of the case, the insanity phase, if you desire to testify on that. But we're also not going there yet. And we're not going backwards either. We're not going to the guilt phase at all. I also want to make sure you're aware and not surprised by, I made my ruling on October 11th of this year regarding impeachment by prior convictions. Denied the impeachment use for some of your older convictions and granted impeachment use for another conviction.
Witness tampering.
Witness tampering. So I just want you to know up front, I don't know if the state will do it because I don't try cases, but they have the ability to impeach your credibility through use of that witness tampering conviction. Okay? All right, just wanted to let you know that. Are you prepared to testify?
Yes, I am.
Okay, very good. Let's call the jury right back in.
All rise for the jury.
Thank you. You may be seated. Mr. Holloway, I'll turn to you for your testimony, please. And I don't mind if you do this sitting down, if it's more comfortable for you. Do it whatever way you want.
Thank you.
Okay.
This document says armed assault to rob. It was a guilty plea. May 14, 2003. The charge was assault to kill. Assault and battery with a dangerous weapon. Those were the charges. I was never charged with armed assault to rob. However, in that case, I saved somebody from being beaten.
Objection, relevance.
We're talking about the case, Your Honor. Talking about the incident itself, the indictment itself.
Yeah, the only element that's at stake is whether there is a conviction for it. The underlying facts and circumstances are not relevant. It's just whether there was a conviction for it or not. So we can't go into that.
Okay.
You're welcome. No problem.
I was not convicted of armed assault to rob. Also, the conviction is subject to an annulment, still eligible for annulment, which would be my option or opportunity to remove that from my record. Unfortunately, I'm poor. I don't have enough money to pay for a lawyer for everything that happens in my life, so I tried to do it myself, and I got denied. I don't know why, but tried to go for a new trial now that I'm a little more educated in the law, and I got denied. So that conviction that is on my record is still there, 20 years later. That's all I have to say, Your Honor.
Thank you. Any cross-examination at all?
Wait, Your Honor.
Very good. Any other witnesses at all?
No, thank you.
Thank you. All right, that concludes the presentation of the evidence to you. I'll now turn to closing arguments. Any closing argument from you, Mr. Holloway, on this particular charge?
Yes, Your Honor.
Go right ahead, sir.
So just want to make sure everybody knows the truth about me. The truth about me is I came a long way. I'm 41 years old. It's been a long time for me. I think I died maybe 2 or 3 times. I'm not sure. I stopped counting. But I changed a lot. I changed a lot of my ways. I changed a lot of the people I was around. I changed a lot of the areas and directions that I was heading in. And slavery was abolished in 1865. I think everybody knows that. We're way past slavery. And the slave trade still exists. This is modern slavery. Incarceration, mass incarceration. Pretty sure everybody sees TV and they see a lot of different shows that show you a lot of different stuff that will make you hate someone that's been through what I've been through. Maybe no one really understands what it is to be a slave to the system. But my life and my story is real. My true story is real. A lot of people that know me know that I'm a stand-up, solid guy. I would jump in the middle of a traffic highway, speeding traffic to save a kid, save an old lady walking across the street. That's me. I would die for that. I grew up poor. I didn't have both parents in my household. I didn't have too much options. I barely had school clothes. But these convictions are 20 years old. This conviction was an accident because I wasn't financially stable to pay for an attorney that would defend me in a self-defense manner. So now the state wants to bring this to you in my new life, my better life, while I'm doing great. I'm doing awesome now. I have more than one job. I have two jobs, 3 jobs, and I'm helping my family with construction jobs. I got 3 kids, 2 boys, 1 girl, and I'm doing better. We go to water country and we go through the big pool and the slides. Spend time with my parents. I'm a different person now. I'm not a convicted felon. Thank you.
And closing by the state, please.
Thank you. He is a convicted felon. He admitted to it. He tried to annul the conviction because it's a conviction. His conviction, that exhibit that we just talked about, he tried to get that annulled because he was convicted of it. He admits to this. The conviction itself is good evidence, but his own testimony to you, that is what you should consider as well in assessing whether or not the state has proven this element, this prior conviction, beyond a reasonable doubt. We've done so. Thanks in part to Mr. Holloway. Thank you.
Thank you. And now I'll just repeat that instruction for you, and this will begin your deliberations. We'll have just the one exhibit, Exhibit 34. We'll get it redacted and then get that into you for your determination. Again, as I told you before, this phase of the trial relates to the possession of firearm indictment, charge ID number 1678544C. The third element of this crime requires the state to prove beyond a reasonable doubt that, number 3, the defendant has been convicted in either a state or federal court in this or any other state of a felony against the person or property of another. As such, your sole determination for this phase of the trial is whether or not the state has proved this part or element beyond a reasonable doubt. Importantly, as you make this decision, please use the legal instructions provided to you during the first phase of the trial. I've listed those out. I don't have to repeat it for you again. And again, there is a verdict question for you to answer on this element of the crime. Since you've already answered with a guilty finding on the first 2 elements of the crime, I do not need another finding on those 2 elements. So Liz will get you the supplemental legal instruction on this charge, which is just a page long. We'll get you the exhibit once it's been redacted, and you are now in deliberations on that particular charge. Again, follow those duty to deliberate instructions I've given you. It's now your time to discuss this particular element of the possession of firearm charge, again, much like you did on all of your other verdicts. Listen to each other carefully, engage in a discussion, and understand that it's important for you to reach unanimous agreement, but only if you can do so honestly and in good conscience. So I know you'll follow all my previous instructions, and you'll follow this rather simple and direct legal instruction and answer the question. When you are done your deliberations, again, just knock on the door and the court officer will get the verdict question from you. If you have any legal questions, much like you did before, you can write those down and I will answer those for you after consulting with the attorneys and Mr. Holloway. So you are released to deliberate as part of the second phase of this trial. I'll get you the instruction and the exhibit into you for your consideration. And I'll ask the foreperson, do you still have the prior legal instructions with you in the room?
Yes, we do.
Very good. You can utilize those since they're right in the room. Very good. You're released to deliberate on this one.
All rise for the jury.